Okay, I'm live during Chapter 14, Guilty Pleas, Plea Bargaining. The great majority of criminal cases in the United States are disposed of by a plea of guilty rather than by trial. The guilty plea is very often a negotiated plea, that is, a defendant's agreement to plead guilty to a criminal charge with a reasonable expectation of receiving some consideration from the government. Sometimes this plea is a result of nothing more than implicit plea bargaining. There is no actual bargaining between the defendant or his attorney and the prosecutor or judge, and the defendant enters his plea merely because it is generally known that this is the route to a lesser sentence. But more common is explicit bargaining, in which the defendant enters a plea of guilty only after a commitment has been made that concessions will be granted or at least sought in his particular case. One common form of plea negotiation consists of an arrangement whereby the defendant and prosecutor agree that the defendant should be permitted to plead guilty to a charge less serious than is supported by the evidence. A second form involves an agreement whereby the defendant pleads on the nose, that is, to the original charge, in exchange for some kind of promise from the prosecutor concerning the sentence to be imposed that he will recommend or not oppose a certain sentence, or even that he will ensure that the sentence will not exceed a certain amount. Still another kind of plea bargain, the one most likely to be illusory, is where the defendant pleads on the nose in exchange for the prosecutor's promise to drop or not file other charges. Plea bargaining is a long time, though only recently, highly visible practice in the United States. There is considerable disagreement as to what caused this practice to develop and continue, though it seems likely a combination of factors is involved. One explanation is that plea bargaining is a response to crowded court dockets, but this is not inevitably the case, for negotiation practices have developed at times in places where there was no serious court congestion. Some have attributed plea bargaining to inadequate public defenders, the financial incentives of private attorneys, the laziness of prosecutors, but this is hardly an entirely accurate or complete explanation either. Certainly, there are at least some more favorable explanations, such as that there are today fewer genuine disputes of fact to be resolved by trials because of the increased professionalism of police and prosecutors and the enhanced role of defense attorneys at the pretrial stages. But whether the institution of plea bargaining is viewed favorably or unfavorably, there is no denying that this process of negotiation for and granting of concessions can give rise to difficult and important legal issues. Just how much pressure may the prosecutor put on the defendant in an effort to induce him to go the guilty plea route? What are the defendant's rights if, notwithstanding his plea, he does not receive the contemplated concessions? What constitutes ineffective assistance by defense counsel in a plea bargaining context? Is the prosecutor obligated in a guilty plea case to disclose to the defendant evidence favorable to the defense to the same extent as in a case going to trial? Those issues are explored in the Supreme Court decisions in this section, starting with Bordenkircher versus Hayes. And I'm interested to see how many more cases are going to be in this chapter. So there'll be Santo Bello versus New York, Missouri versus Fry, United States versus Ruiz, and then we'll get to part 2 of the chapter, requisites of a valid plea, looking at Boykin versus Alabama, Henderson versus Morgan, and North Carolina versus Alford. So this is about a 30-page chapter, which this particular next case won't be terribly long. It's a 1978 case. Justice Stewart delivered the opinion of Bordenkircher versus Hayes. Paul Hayes was indicted in Fayette County, Kentucky on a charge of uttering a forged instrument in the amount of $88.30, punishable by 2 to 10 years in prison. Hayes and his retained counsel met with the prosecutor, who offered to recommend a sentence of 5 years if Hayes would plead guilty, and added that if Hayes did not plead guilty, he would seek an indictment under Kentucky Habitual Criminal Act, which would subject Hayes to a mandatory sentence of life imprisonment by reason of his 2 prior felony convictions. Hayes chose not to plead guilty, and the prosecutor did such an indictment. A jury found Hayes guilty on the principal charge of uttering a forged instrument, and in a separate proceeding further found that he had twice before been convicted of felonies. As required by the habitual offender statute, he was sentenced to a life term in the penitentiary. The Kentucky Court of Appeals rejected Hayes' constitutional objections to the enhanced sentence, and on Hayes' petition for a federal writ of habeas corpus, the district court agreed that there had been no constitutional violation in the sentence or the indictment procedure. The Court of Appeals for the Sixth Circuit reversed on the grounds that the prosecutor's conduct had violated the principles of Blackledge v. Perry, which protects defendants from vindictive exercise of prosecutors' discretion. So, let's just see here. So, what did the trial court do? We know that the appeals affirmed whatever the district court said, and then the habeas corpus, everything was really affirmed. So it was like convicted, affirmed. And then we went to the Supreme Court, which took issue with this, comparing it to Blackledge v. Perry. Vindictive exercise of prosecutor's discretion. It may be helpful to clarify at the outset the nature of the issue in this case. While the prosecutor did not actually obtain the recidivist indictment until after the plea conferences had ended, his intention to do so was clearly put forth at the outset of plea negotiations. Hayes was thus fully informed of the true terms of the offer when he made his decision to plead not guilty. This is not a situation, therefore, where the prosecutor, without notice, brought an additional and more serious charge after plea negotiations relating only to the original indictment had ended, with the defendant's insistence on pleading not guilty. As a practical matter, in short, this case would be no different if the grand jury had indicted Hayes as a recidivist from the outset, and the prosecutor had offered to drop that charge as part of the plea bargain. The Court of Appeals nonetheless drew a distinction between concessions relating to prosecution under an existing indictment and threats to bring more severe charges not contained in the original indictment. Yeah, because there should be one, okay? Concessions versus threats. A line thought necessary in order to establish a prophylactic rule to guard against the evil of prosecutorial vindictiveness. Quite apart from this chronological distinction, however, the Court of Appeals found that the prosecutor had acted vindictively in the present case, since he had conceded to the indictment that the indictment was influenced by his desire to induce a guilty plea. The ultimate conclusion of the Court of Appeals thus seems to have been what prosecutor acts vindictively and in violation of due process of law whenever his charging decision is influenced by what he hopes to gain in the course of plea bargaining negotiations. We have recently had occasion to observe that whatever might be the situation in an ideal world, the fact that guilty plea and often concomitant plea bargain are important components of this country's criminal justice system. Properly administered, they can benefit all concerned. The open acknowledgement of this previously clandestine practice had led this court to recognize the importance of counsel during plea negotiations, the need for a public record indicating that a plea was knowingly and voluntarily made, and the requirement that a prosecutor's plea bargain promise must be kept. The decision of the Court of Appeals in the present case, however, did not deal with considerations such as these, but held that the substance of the plea offer itself violated the limitations imposed by the due process clause of the 14th Amendment. For reasons that follow, we have concluded the Court of Appeals was mistaken in doing so. The court in North Carolina v. Pierce that the Due Process Clause of the 14th Amendment requires that vindictiveness against a defendant for having successfully attacked his first conviction may play no part in the sentence he receives after a new trial. The same principle was later applied to prohibit a prosecutor from reindicting a convicted misdemeanant on a felony charge after the defendant had invoked an appellate remedy, since in this situation there was also a realistic likelihood of vindictiveness, from Blackledge v. Perry. In those cases, the court was dealing with the state's unilateral imposition of a penalty upon a defendant who had chosen to exercise a legal right to attack his original conviction, a situation very different from the give-and-take negotiation common in plea bargaining between the prosecution and the defense, which arguably possess relatively equal bargaining power. The court has emphasized that the due process violation in cases such as Pierce and Perry lay not in the possibility that a defendant might be deterred from the exercise of a legal right, but rather in the danger that the state might be retaliating against the accused for lawfully attacking his conviction. To punish a person because he has done what the law plainly allows him to do is a due process violation of the most basic sort, and for an agent of the state to pursue a course of action whose objective is to penalize a person's reliance on his legal rights is patently unconstitutional. But in the give and take of plea bargaining, there is no such element of punishment or retaliation so long as the accused is free to accept or reject the prosecution's offer. Plea bargaining flows from the mutuality of advantage to defendants and prosecutors, each with his own reasons for wanting to avoid trial. Brady v. United States is the quote that comes from. Defendants advised by competent counsel and protected by other procedural safeguards are presumptively capable of intelligent choice in response to prosecutorial persuasion and unlikely to be drawn to false self-condemnation. Indeed, acceptance of the basic legitimacy of plea bargaining necessarily implies rejection of any notion that a guilty plea is involuntary in a constitutional sense simply because it is the end result of the bargaining process. By hypothesis, the plea may have been induced by promises of a recommendation of a lenient sentence or a reduction of charges, and thus by fear of the impossibility of a greater penalty upon conviction after trial. While confronting a defendant with the risk of more severe punishment clearly may have a discouraging effect on the defendant's assertion of his trial rights, the imposition of these difficult choices is an inevitable and impermissible attribute of any legitimate system which tolerates and encourages the negotiation of pleas. It follows that by tolerating and encouraging the negotiation of pleas, the court has necessarily accepted as constitutionally legitimate the simple reality that the prosecutor's interest at the bargaining table is to persuade the defendant to forgo his right to plead not guilty. It is not disputed here that Hayes was properly chargeable under the recidivist statute since he had in fact been convicted of 2 previous felonies. In our system, so long as the prosecutor has probable cause to believe that the accused committed an offense defined by statute, the decision whether or not to prosecute and what charge to file or bring before a grand jury generally rests entirely in his discretion. And that's a quote I recognize, but it doesn't, and it points to footnotes, but in the footnotes it doesn't tell me what case that's coming from. Moving on. Within the limits set by the legislature's constitutionally valid definition of chargeable offenses, the conscious exercise of some selectivity in enforcement is not in itself a federal constitutional violation so long as the selection was not deliberately based upon an unjustifiable standard such as race, religion, or other arbitrary classification. To hold that the prosecutor's desire to induce a guilty plea is an unjustifiable standard, which, like race or religion, may play no part in his charging decision, would contradict the very premise is that underlie the concept of plea bargaining itself. Moreover, a rigid constitutional rule that would prohibit a prosecutor from acting forthrightly in his dealings with the defense could only invite unhealthy subterfuge that would drive the practice of plea bargaining back into the shadows from which it has so recently emerged. Since there is no doubt that the breadth of discretion that our country's legal system vests in prosecuting attorneys carries with it the potential for both individual and institutional abuse. And broad though that discretion may be, there are undoubtedly constitutional limits upon its exercise. We hold that the course of conduct engaged in by the prosecutor in this case, which no more than openly presented the defendant with an unpleasant alternatives for foregoing trial or facing charges on which he was plainly subject to prosecution, did not violate the due process of the 14th Amendment. Accordingly, the judgment of the Court of Appeals is reversed, and Blackman, Brennan, and Marshall all dissent from the, I want to say, majority opinion. Powell dissents, so it might be a plurality opinion. So read that separately.